The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about guardianship and divorce in Illinois. And specifically, we'll discuss when a guardian can file for divorce on behalf of their ward in Illinois. We'll talk about the process for filing for divorce when you're a guardian. And also, we'll talk about annulment of a marriage based on mental incapacity to marry, and when a guardian can do that. So first, let's talk about when a guardian can file for divorce on behalf of a ward. There's a difference between plenary and limited guardianship. A plenary guardian has basically power to make all sorts of decisions for the ward. A limited guardianship is basically limited to the decisions that are explicitly stated in the order that declared the guardianship. So in a limited guardianship, the guardian can only make specific, explicitly ordered types of decisions that the courts say they can make. Plenary is just kind of a wholesale guardianship over all decision making. Plenary guardians can initiate divorce proceedings on behalf of a ward with permission of the court. They can also continue with existing divorce actions that were filed prior to the initiation of the guardianship. When a guardian is going to initiate divorce proceedings on behalf of a ward, they have to use the substituted judgment rule. And this means that they have to make or try to make the same decision the ward would have made were he or she mentally competent to do so. So this means that the guardian has to take into account the religious and ethical beliefs of the ward, and also anything that the ward said about what his or her wishes would be in that situation while the ward was mentally competent. This only comes into play if the decision the ward would have made based on the substituted judgment rule is different than the guardian's decision based on the guardian's assessment of the ward's best interest. If there's a conflict there, then the decision the ward would have made overrides the guardian's decision about the ward's best interest. So an example of this might be if the ward was very religious and stated many times that no matter what, he or she would never get divorced because that was against his or her religion, then even if the guardian believes that it's in the ward's best interest to get divorced, the guardian has to account for the ward's religious beliefs, and in that situation, it may be inappropriate to file for divorce on behalf of the ward based on the substituted judgment rule. So, assuming that the substituted judgment rule lines up with the ward's best interest in the guardian's view, the guardian can initiate a divorce. But you don't just file for divorce on your own if you're the guardian. What you have to do is get permission of the guardianship court to file for divorce. You do this by filing a petition with the probate court that has jurisdiction over the guardianship case, usually the one that instituted the guardianship in the first place, and seek permission from the judge to file for divorce. In order to gain permission from the judge, you have to demonstrate by clear and convincing evidence that the divorce is in the disabled adult's best interest. Clear and convincing evidence is a higher standard than the normal preponderance of the evidence standard. Preponderance of the evidence is you have to show that what you're trying to prove is 51% likely to be true, more likely than not. Clear and convincing evidence is what it says. The evidence has to be very, very clear. It's more than a 51% either or decision. It's a higher standard of proof. If the probate court grants permission to file for divorce, then the guardian can file a divorce petition with the appropriate circuit court. Now let's talk a little bit about annulment of marriage. A marriage can be annulled based on the lack of mental capacity to marry at the time of marriage. A petition to annul the marriage must be filed within 90 days of the guardian learning of the disabled adult's incapacity to marriage or that the marriage happened. It doesn't mean necessarily just because you have a guardianship doesn't mean that you don't have the capacity to marry. So just because you're adjudicated disabled for the purposes of having a guardian awarded doesn't mean that you're not capable of marrying. A mental capacity to consent to marriage means that you are able to understand the nature, effect, and duties of the marriage. So if you're able to understand those things, then you have the capacity to consent to marriage. If you don't have the mental capacity to understand those things, then you don't, and the guardian can file for an annulment of the marriage within 90 days of learning that you got married while under the effect of a disability that prevented you from having that mental capacity. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices all around Chicagoland for your convenience. If you found this helpful, please subscribe to us on Apple Podcasts, SoundCloud, and YouTube. Or you can subscribe to our email list by going to learn-about-law.com. Any of those methods will allow you to be informed of the daily article and video posts that we make. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.